Hello and welcome to this week's episode of the Gavel. I am Benny Ark. Today we continue our series on the report of the Committee on the Electoral Act Amendment, and it was anything but quiet on the floor of the House. During the clause-by-clause consideration, lawmakers engaged in a heated debate on Section 29, subsection 6. This provision states that where a court finds that a candidate has supplied false information in an affidavit or any document submitted to the Independent National Electoral Commission, INEC, particularly on constitutional eligibility requirements, the court shall issue an order disqualifying that candidate. But it does not end there. The section further provides that the sponsoring political party may also suffer the consequences, with the possibility of the runner-up being declared winner, provided it meets the required criteria. Lawmakers for and against the provision took turns to stress one key message: that the issue of false declaration is a serious matter with far-reaching implications for the credibility of the electoral process and the sanctity of democracy.
So the person with the second highest number of votes is the one to be declared as the winner?
Yes.
Are we comfortable with that? It's okay.
Yes. Any other one on this 20? Yes, I said I'll call you after. Yeah, go ahead.
Section 3.
29.1. You said
29.1, Mr.
Yes.
Chairman.
Mr. Chairman, 29.3.
Please,
Mr.
it's not
Chairman.
good to use your microphone unless you are recognized. You are disrupting the House. This is an intellectual exercise. Don't interrupt people when they are airing their view.
I want to speak to 29.6, sir.
29?
29.6.
6, okay?
This subsection 6 and 7 makes the provision of subsection 5 nugatory, in the sense that subsection 5 says that where an aspirant in a primary feels that another aspirant has filed fake documents and goes to court to challenge that aspirant in the hope that is going to replace that aspirant at the primaries. Subsection 6 now says if election has been conducted while he is still at court trying to get the legitimate mandate of the party, if they have gone to do the general election, then victory is given to the person that comes second, the party that comes second, by virtue of subsection 7. Now, the man that has gone to court, what is his benefit? No, it does not matter. It does not matter, sir.
What do you want?
If
Honorable
a criminal, Mr. Chairman, sir, I have the floor, sir. Mr. Chairman, sir, if a criminal succeeds in buying the party, in buying the mandate of the party, and an innocent person goes to court to challenge that criminality within the party, he should not be made to suffer for it. I am sorry. My amendment, sir, is that you can disqualify the candidates, but allow the party.
Whenever a court determines that a candidate is being disqualified, so such a matter should be referred to INEC to conduct election, rather than to give a court power to pronounce a candidate or any person or that becomes second. Because some people has mastered a way of getting season election in the court. So allowing this is a serious gaffe in a manner where that a court will now be determining who deserves to be elected or to pronounce being elected or not. So I think that, yes, and this is power of the INEC. Whenever a candidate is being disqualified, therefore INEC should conduct fresh election with giving the political parties to field candidates that are qualified to participate. It will be more free and fair.
All right.
Thank you.
They should go back to election. Have you considered the cost of doing election?
Chairman. Mr. Chairman. Chairman.
I'm just saying.
Chairman.
The time it will cost to do election, the logistics to do election. If somebody came second.
Chairman.
Chairman. Let me hear Minority Leader.
Amendment.
Mr. Chairman.
Mr. Chairman, my dear colleagues, if we consider what Honorable Kuye and Dr. just raised, there is need for us to look at these clauses again. Firstly, when a candidate for a party primaries, that is sub-5, raises an issue of qualification and goes to court, we expect that if he gets judgment, he should reap the benefit of that litigation. Now, but what we have done here is that whilst the matter is still in court and the election is conducted, if he gets judgment, not even his party, because the person will be disqualified, his party will be disqualified, and the second person will now benefit from it, which is not right. Now, Doctor has also suggested that where the person is disqualified, we should be allowed that INEC should conduct a fresh election. I think that way, the person who went to court will be given an opportunity. And therefore, I will pray that we amend this because of Clause 5, because Clause 5 will be useless if we leave it the way it is, giving a candidate opportunity to go to court. And then when he succeeds, if election has been conducted, he will no longer reap the benefit of his litigation. Let us look at it, remove the political party, and allow INEC to conduct fresh election where there is disqualification. Thank you, sir.
Chairman.
Okay, this is an amendment that has been proposed. And once there is an amendment like this, we'll ask for a seconder.
Chairman, you have to
call us. Doctor, move that motion.
Chairman, look at this side now. Look at this side.
I will ask for a seconder. I will ask for a seconder before we throw the vote. Any seconder to this amendment?
Chairman, look at this side now.
I stand here to support this submission that if a court disqualifies somebody for certificate forgery or fundamental requirements by the Constitution, that the political party should be given opportunity to feed a candidate in a fresh election with with also
information, Chairman.
Observation, all the people who are living.
That the candidate so found, to have forged documents to deceive the court and his party should be prosecuted criminally with immediate effect by INEC.
Observation.
That's my submission, Mr. Chairman.
Mr. Chairman, Section 29(5) deals with dispute arising from conduct of primary election. If a candidate or an aspirant in a party primaries complains, he has a window within that provision to go to court and challenge the qualification of any member of any of the aspirants in the context. Mr. Chairman, the solution to Section 25(5) lies squarely in the ability of pre-election matters to be conducted and concluded before the general election. That is the solution to that provision. If we can amend the Electoral Act to make a provision that every dispute arising from the conduct of primary elections should be conducted and concluded before the conduct of general election. In such case, whoever wins in the course of the dispute becomes the candidate of the political party. The issue of what becomes the benefit of the person will no longer arise. That is one. Mr. Speaker, coming to Section 29, sub 6 and 7,
it is very clear. One of the grounds upon which a candidate in an election can approach the tribunal challenging the conduct of that election is on the grounds that a candidate in that election did not have the requisite qualification as at the time of conduct of that election. It can be raised by a candidate of the other political party or any other political party that take part in that election. And if he succeeds, the candidate with the second highest number of votes cast at that election becomes the winner of that election. However, if it is in relation to the primaries, Mr. Chairman, the solution lies for us to make a provision that all pre-election disputes be determined prior to the conduct of general election, in which case there won't be this issue of what becomes the benefit.
The solution is already there.
Yes,
that everything will be finished before
then
election is there.
Mr. Chairman, if you also look at section 29 sub 9, if you look at section provision of section 29 sub 9, you also see that what it means is that a political party swims and dies with the candidate of his choice. If a political party fails to conduct due diligence on the candidates on these candidates for the election, and in the course of it, a candidate chosen by that political party is found wanting, Mr. Chairman, it is at the peril of that political party. He should bear the blunt.
As he rightfully said, when political parties want to pick their candidates, they do a screening process. So if a political party has gone through the screening process and done their due diligence, and yet they could not find the discrepancies in a candidate's qualifications, that political party should be penalized. So the person that comes second does not necessarily need to be made the winning party. They should conduct new elections and omit that political party that could not conduct proper screening for their candidate. Thank you, Mr. Speaker.
I think the issue here is, if we think deeper, who wins an election? Is it the candidate or is it the political party? From what we have seen so far, from our past experience and what we have seen so far, it looks like we rely more on the political party and not the candidate. And that's the reason why in almost every election we have in this country, in fact all elections we have in this country, we do not have the name of the candidate. Instead, we have the political party, and that tells me it's the political party that wins the election. So as a result of that, I feel in a situation like what he was talking about, if somebody loses, if the person that wins the election gets disqualified, it's the political party that gets disqualified. The person that should be the eventual winner of that election should not be the person that comes second. It should be someone from that same political party, which means that there should be an opportunity for the person that came second in the primaries or a run in that election.
The duty of care is owed by the political party. And that duty of care is to be diligent in following the guidelines as provided by INEC in the screening of their candidates. Any attempt to go outside the parameters of that duty should be punishable. If not so, we will go in a circle of repeated incompetence being recycled over and over again, and that will cost INEC more. That will affect the logistics. But understanding that the soul that sinneth shall die. If you deliberately make that mistake, then you are ruled out of order. so it is important that we understand that it is not come one, come all. There is a standard laid down by INEC. Parties should comply with it. If you fail to comply, you pay the price. 29 has carried.
We continue with the clause-by-clause debate on the Electoral Act Amendment report as members meticulously examined each provision, weighing its legal implications, enforceability, and impact on future elections. Arguments were robust, positions were clearly stated, and once again, the lawmaking process played out in full public view, underscoring the complexity and importance of electoral reforms in a democratic system.
31 carried. 34. Yes, Honorable Sada. 32. Oh, 32? Okay, we reverse ourselves. 32.
Mr. Chairman, I require the explanation of the chairman of the committee on 32, subsection 2, where he is saying substituted with an affidavit within 14 days after publication. While the original
supported, not substituted. Supported.
Supported with an affidavit within 14 days after the publication. Mr. Chairman, you should remember, if you go back, it has given a window before the election 150 days. That is 5 months, 1 day. Then here, the original act is saying supported with an affidavit.
Honorable member, listen to Honorable Sada. Honorable Bashir. Honorable Bashir. Listen to Honorable Sada, because what he's saying makes a lot of sense. Go ahead.
Mr. Chairman, the publication first will say, will give you 5 months. Then here is saying here is giving you, again, the original act is saying subsection 2 is giving you supported with an affidavit not less than 90 days. And then the amendment is giving you a window, is saying within, I think it's too tight, considering the documentation and every other necessary things that has to do with the submission of this list. I think we should give the political parties the maximum time they require in order to attend to so many other things that are involved in submitting this list. 14 days within 14 days window is too short.
Honorable Sada, are you saying that if a publication came from INEC and your party's candidate's name is missing, and you observe that it is missing, are you saying that observation is to the fact that you don't even have the name?
Mr. Chairman,
because before you can observe that something is missing, it means that it's available but not included.
Mr. Chairman,
but if in this case you say 14 days is not enough to carry what is available and replace in the space that is missing.
Mr. Chairman, since INEC did not object to this amendment, since INEC did not object to the provisions of the original act, I think INEC must have seen the reason for this not less than 90 days.
We are not making this law because of INEC like this or not. We are making this law because as parliamentarians,
I'm trying to give opportunities for the political parties to have maximum time for these publications.
So you are saying 14 days is not enough?
14 days is not enough, Mr. Chairman.
To replace a name.
So where you have
any seconder to this amendment? Any seconder to this amendment?
Well, I'm not moving a motion, but I'm just making an observation.
Observation noted. 32, carried. 32-2. 32-2. 34. 34. 42. 42. 47. 50. 50.
Moving on now to our constituency focus segment. This week, we turn the spotlight on Honorable Larry Okunla, representing Surulere 2 constituency of Lagos State, as he shares insights into legislative engagement and matters affecting his constituents. Take a look.
I guess that for me, this almost 2 years now has been very eventful, and I must say my midterm scorecard is in the public domain for people to see. I've laid on the floor of the House 15 critical bills that are pertinent and important to my constituents, and I have another 4 other ones going through rules and business, and so hopefully we should be looking at 19 bills. So these are bills that affect my constituent, that affect Lagos State, and affect Nigeria. So, and as a lawmaker, I must say that for me, what are the policies we need to put in place for good governance? What are the policies we need to put in place for economic gains that would help in making sure that Nigeria is a country where you can rely on that is self-sustenance? And what are the policies we can, as members, be looking at in terms of security, architecture of this nation? Because, that is one critical aspect of our life that is very pertinent now, where we are all yearning for peace. And I must say that the government of Bola Ahmed Tinubu, the president of GCFR, has been so gracious to making sure that our country is safe again. We're beginning to feel the presence of making sure that things are done and are done accordingly. For me as a lawmaker, the pressure is also there on us to see what we can facilitate to our constituents and all that. And I'm sure that in that area, we've positioned it in 3 perspectives: short, medium, long term. What are the short things we can do for our constituents in terms of empowerment, and see how the informal sectors work and all that? So we've been able to do a lot of empowerments for our youths and women to make sure that they also can contribute their own quota to the development of the country. And we've looked at other areas, road infrastructures. We have quite a lot of inner roads that we've actually asked the federal government that is gracious enough to help us in making sure that our road networks are adequately safe and secured in terms of providing solar lights in our environments. And where interventions for transformers are, we've also helped in bringing succor to our people in that line. So in the area of making sure that we also contribute our own quota in terms of educational benefits, we have also giving free JAM forms to our constituents. The last one we did was over 1,000. So we're also doing such interventions, and the federal government too has been so gracious in providing grants for our traders, for our artisans, and all that. Over 1,000 of them have benefited from that scheme on its own. So as a lawmaker, I'm sure that this past 2 years has been quite eventful, and I look forward to another wonderful 2 years coming, where we'll be able to say that we'll beat our chest that we've done so well.
That wraps it up on this week's edition of The Gavel. We would like to hear from you, so please send us your feedback at thegavel@channelstv.com. Until next week when The Gavel comes your way, I am Benny Ark. Stay safe and be well.